Great. Well, hello, everyone. Um, because it's 5 o'clock, we are going to get started, but we will start with some of the overviews about our agency. And so hopefully as more people trickle in, they will be in attendance for the more substantive parts of this presentation. But my name is Marianne Davies, and I'm an attorney at the Disability Law Center. And I do work on our employment team here at the DLC. So just as an overview, this presentation is just general information. It's not legal advice. Only an attorney can give you legal advice and help you with a specific problem or answer a specific question. Just a little bit about the Disability Law Center. If you are new to our organization, we are a private nonprofit organization that protects and advocates for the rights of people with disabilities in Utah. And our mission is to enforce and strengthen the laws that protect the opportunities, choices, and legal rights of people with disabilities. And we envision a just society where all people are treated with equity, dignity, and respect. And we do have a number of teams at the Disability Law Center. This is an employment-specific presentation. But we provide assistance in a number of areas. So we have our intake team, which is referred to as our short-term assistants, and they provide information and referrals for callers. They help. If you call our office seeking assistance, they'll be the first one you talk to. If it's an issue we don't directly work on, they are a very helpful resource and try to provide referrals on issues. We also have our education team, and they work on issues relating to students in education and K through 12 education. We also have an abuse and neglect team. We do public policy work. We have an access and rights team that focuses on an individual's ability to access places of public accommodation. And that includes things such as service animals, whether or not there is a physically accessible building and those type of things. We have our employment housing, and then we have our fair housing program, which actually serves more protected classes than just disability. If you have an issue coming up related to your housing that has to do with discrimination on any of the protected classes, such as race, religion, ethnic origin, you can contact our office to speak to see if there is assistance we can provide on a fair housing issue. So today we'll be focusing on specifically on the reasonable accommodation of working from home and leave. But before we get to that, I want to give a general overview of the ADA provisions, the Americans with Disabilities Act provisions that apply to employment, so that you have a basic familiarity of what reasonable accommodations look like. So the title of the Americans with Disabilities Act that applies to employment, it's referred to as Title I. And under Title I, the ADA makes it unlawful to discriminate against people with disabilities in all employment practices. This includes things such as recruiting, hiring, firing, job assignments, promotions, pay, benefits, anything that's related to employment activities. And then also, it should be noted that it's unlawful for an employer to retaliate against someone for asserting their rights under the ADA, whether that be voicing concerns about discrimination or requesting a reasonable accommodation. So the ADA, under Title I, protects qualified individuals with disabilities. And so qualified means two things. It means first that you can perform the essential functions of your job with or without a reasonable accommodation. And we'll get much more into essential functions because this will come up quite a bit with leave and working from home. But just as a primer, essential functions are those key parts of a job. So for example, being a truck driver, an essential function would be able to drive the truck, maintain, whatever licensure you need, loading, unloading, those type of things. And then you also must possess the skill, education, and certifications or experience necessary for the job. So to get protection under the ADA and employment, you must actually be qualified for the position. So, if you didn't have the necessary licensure or you didn't meet, the education requirements for a position, then you actually then you may not be qualified under that piece of the ADA and may not be entitled to protections. So what we'll be focusing on today primarily are reasonable accommodations. So under the ADA, and this is one thing that I would just like to note about the ADA that is different from other civil rights statutes, is that the ADA actually requires, employers or places of public accommodation, government programs and entity to actually make changes to the way they do things in order to grant equal access. And so that's kind of where reasonable accommodations are originated from, is we're talking about creating an equal opportunity for employees. So employees who may need something different within their job to be able to have the same opportunity that their non-disabled coworkers would have. So reasonable accommodations include any change in the work environment or the way things are customarily done that helps the employee with a disability to enjoy equal opportunities. And that also helps them to attain the same level of performance, benefits and privileges of employment. The ADA doesn't guarantee that you'll do well in your job, but it gives you the chance to have an equal opportunity to do well in your job. So there are different types of reasonable accommodations. And as I mentioned, we will get much more into leave and working from home, but just to kind of talk through some of the accommodations that exist. These include things such as making facilities physically accessible, whether it be adding a ramp or making a bathroom accessible, job restructuring, part-time or modified schedules. So for example, some people have modified schedules where they perhaps come in early or leave a little later. Acquiring or modifying equipment, perhaps, there would be something about somebody would need, a special software to their computer to make it accessible, or changing the physical layout of somebody's office, changing tests, training materials, or policies. So for example, giving individuals training materials in a large font for individuals who may require that, or providing, an interpreter for individuals who are deaf. And you can also, within reasonable accommodations, there's also the reasonable accommodation of reassignment to a vacant position. So there are some things that we know from the law that are not reasonable accommodations. And these include things such as eliminating essential job functions. So for example, if your job was to be work at a front desk and greet visitors, but you requested to have limited interactions with the public, that could be a problem in terms of your reasonable accommodation request. Also, lowering production standards that are applied to all employees. That is not usually going to be a reasonable accommodation. That's usually seen as unreasonable. Providing personal use items. So for example, requesting that your employer provide you with a wheelchair or a hearing aid is not a reasonable accommodation. Personal use items are those items that you require throughout the day, not just at work for your disability. Asking for a change in your supervisor is not a reasonable accommodation, or excusing violations of uniformly applied conduct rules. So for example, if you have a no call, no show at work, asking to excuse that as a reasonable accommodation would not be seen as that would not be seen as a reasonable accommodation request under the ADA. And then also this last category of accommodations that are not reasonable are those that impose an undue hardship on the employer. And undue hardship is a really case fact specific issue. And that really depends on what the request is, and then what are the specific factors about the employer's, whether, for example, if you requested, something that required a really large expenditures of funds, that may be reasonable for a very large employer, and it may be an undue hardship for a smaller employer. But it's really fact specific depending on your job and your employer, and a lot of individual factors. And I should say, just as we go on, if you have questions, you can type them into the question box, and we can answer those throughout. And I will also save time at the end to go over questions as well. Oh, excuse me. So how can you request a reasonable accommodation? So requesting a reasonable accommodation, there are many times that your employer may have an accommodation process that they ask you to follow. However, under case law and under the ADA, you really, it doesn't have to be anything too special, or, we like to refer to the no magic words. You don't actually have to say to your employer that you are requesting a reasonable accommodation using those exact terms. So long as you are identifying that you need a change or modification that's because of your medical condition, that will usually do the trick. It doesn't require you to disclose your exact disability, and it doesn't have to be in writing. However, we would generally advise individuals that putting things in writing is really best practice to make sure that you can document, when you submitted your request, what it was, and saving any correspondence, I think, is usually the best thing you can do for your reasonable accommodation requests. So just to move into our specific working from home and leave as accommodations, I wanted to focus this presentation in part on working from home, because this has really become such a prominent part of our kind of work life during the pandemic. And we're certainly in a little bit of a transition time, kind of pre-pandemic, to how we all work now. And I think working from home has not only been more popular among employers, but also something that employees are looking to utilize more themselves, now that we have more technology to make that realistic. The other reason I wanted to be able to focus on working from home is that what we saw at the disability law centers through different periods in the pandemic, when cases started to fall, we certainly had increased calls from individuals who employers, as they were considering bringing people back into the office, that individuals who had been working from home successfully, had a lot more interest in being able to request working from home as a reasonable accommodation. So when it comes to working from home, I think a primary question to ask is, what are the essential functions of your job? And can these only be done in the office? So as we talked about, a reasonable accommodation request, an accommodation request, in order to be found reasonable, can't get rid of the essential functions of your job. So for example, you can't be a truck driver and ask to not drive. That's not going to be a reasonable accommodation. So when thinking about what are the essential functions, because that's probably a question you may be asking. Unfortunately, most attorneys' answers are to most questions, that really depends on a lot of things as to whether or not something you do is an essential function. So, some of the things to consider are how often you do the task and the importance of it. Are there others available to perform the task? Do other employees in your same position perform the task? What does your job description say? These are all things that I think are questions to ask about your own position and whether or not, one of your key, essential functions, whether or not you're asking to get rid of an essential function or not. Some of the things that I've had come up during the pandemic, involved individuals who were able to do the majority of their job from home, but required some things to be on site. There were, requirements that had to do with actually, either coming into the office to process lab tests or handle mail, or, be able to, meet with clients, those type of things. And it's certainly, with the pandemic and everything, it has been, a difficult period of time for people as they've faced having to come into the office. But if there are things, you may only need to come into the office to process, a lab test once a month. But if that's a really important part of your job and something that only you can do and others in your same position come in and do, then that may be an essential function. And asking, not to do that and have somebody else do it for you may be an undue burden. So generally what one thing to focus on is, let's say you're not, sometimes you have a scenario in which you're able to perform most of your job tasks at home, but you may be required to come in now and then for a specific function. That is one type of scenario. Another scenario is, let's say the case numbers are falling and your office decides we want to bring everybody back to the office, because we want people in the office. So that raises a question about, is being on site an essential function? Is just the fact that you are working in the office, is that something that is an essential function of your job that you have to do? And I think that's a complicated answer. So prior to the pandemic, telework was not as widespread, but it's certainly been used as a tool during this to decrease the spread of COVID-19. And we now have new technologies such as Zoom, Microsoft Teams that have made telework much more possible, and more workers are now working from home. So it's a little bit uncertain, because prior to the pandemic, most case law held that just being physically in your office was an essential function. That if your employer said it's essential that you be in the office working with your coworkers, that was generally upheld. But now we have a lot of people working from home. We have some hybrid situations, and we have technology that makes working from home more possible. So when considering if, whether or not working from home is a reasonable accommodation request, I think there's some things to look at. So for example, are other employees in your same position on site, or are they working from home as well? If they're working from home, and there's nothing different about their job, but your employer wants just you to come in, then it may be likely that it's a reasonable accommodation request to request that you continue to work from home. I think, considering things such as how much time by employees generally in the office is spent working at the office. Are most people in your office all working from home and only, a handful of people are coming in? Is there available technology that makes it effective for you to do your job at home? If part of your job is to do tasks such as, opening and receiving the mail, sending out packages for your employer, those are things that you likely need to do in the office. But if there are, if if some of your job requires, having meetings with coworkers or meeting with clients, does your office have the available technology to make those things, effective to actually just perform from your home? So I think the the um, where we are right now with working from home in the pandemic is that the case law hasn't actually caught up to current workplace conditions. Like I said, prior to the pandemic, generally we're asking somebody to just perform their job on site was seen as an essential function. I think that's a little bit up in the air now. And I think, when you consider, whether or not my accommodation request to work from home may be reasonable, I think looking at, whether a majority of employees or employees are in your same position are working from home, could be really helpful to thinking through that. And if your employer says, no, you cannot work from home full time, there are alternatives that you could consider, such as, is there a hybrid arrangement where you instead come into the office, for 2 days a week, and then you spend the remainder of your time working from home? Um, are there the other thing you could possibly consider is reassignment? So if in your current position you have to do on-site duties, but you're not able to come on site because you are, immunocompromised, is there another position that you could be transferred into that you could do entirely offsite while working from home? Um, or if you are immunocompromised, are there ways to make your office safer? So, for example, could your employer provide you with personal protective equipment or provide you with your own office? Could you come in at off hours to perform those tasks? So, for example, if a key duty is opening the mail, and that's the only reason you need to come into the office, could you do that at hours where there would be nobody else working? Certainly the pandemic and the spread of COVID-19 has complicated, people's abilities to come into the office. But I think, so long as your employer, when I think if your employer says no to working from home, I think suggesting some of these alternatives are something to consider and discuss with your employer and your concerns to see how you could be accommodated. So I want to transition into requesting leave as an accommodation. This is a really common accommodation request. And I want to go through a few types of leave before we get right into leave as an accommodation. And I want to go over these because typically in my experience as a plaintiff's attorney is that human resources offices can get a little confused between different types of leave, between FMLA leave and workers' compensation and short-term disability policies, and it's a little confusing to keep these all straight, but these all interact and overlap when people are requesting leave. So I just want to go through some of the types of leave that are available so that as you're interacting with your employer that you're able to have be informed about what types of leave are available, and then also thinking about leave as an accommodation. So one type of leave is the Family and Medical Leave Act. This is usually referred to as FMLA. It provides 12 weeks of unpaid leave in a 12-month period for things such as, the birth of a child, adoption of a child, or placement through foster care, to care for a spouse, child, or parent with a serious health condition, or if you yourself have a serious health condition that makes you unable to perform the essential function of your job. So this does apply to all public employers, and it applies to private sector employers with 50 or more employees. So when considering if you are eligible, just keep those in mind. And then also eligibility for FMLA requires that you have worked 1,250 hours during the 12 months prior to the start of your FMLA leave. Other types of leave include short-term and long-term disability. So short-term and long-term disability policies, these are voluntary insurance policies. Not every employer offers them, some do. And these are voluntary insurance policies that replaces part or all of an employee's income in the event of a non-job related temporary disability. Typically, if you have a job-related disability, then you have other benefits as under workers' compensation. We primarily only focus on the Americans with Disabilities Act. So unfortunately, we're not the best resource source for questions on things like workers' comp or specific questions about short-term disability, but these do get brought up a lot with leave, so I just wanted to make sure we address them. So short-term disability usually, so it replaces part or all of an employee's income. The short-term disability usually runs for about 3 to 6 months. And then some, employers, offer the long-term disability for longer periods, such as 5, 10, 20 lifetime years, depending on your plan. And then usually under these policies, you can collect about 40 to 70% of your income. And if you have specific questions about short-term disability, it's usually best to check with the either your office or the plan administrator of that specific insurance policy to see what is covered. So getting into leave as a reasonable accommodation request. So I think this is where it can be a little confusing for probably both employees and employers, that there's so many types of leave offered. But requesting leave as a reasonable accommodation it can certainly be a reasonable accommodation. So unlike FMLA, it's not limited to 12 weeks like 12 weeks within, a certain time period. And it can be used on a continuous or intermittent basis. So when you think of continuous leave, that would be a scenario in which, maybe you need a period of time to recover. So for example, you need 2 months of leave to recover, or intermittent in that, maybe you need a day of leave a week or a month to receive, so for example, if you have cancer and undergoing treatment, maybe you need 1 day of leave a month in order to get that treatment. So under the ADA, an employer must consider providing unpaid leave, and it does not have to be paid, as a reasonable accommodation, so long as it doesn't create an undue hardship. And that applies even when the employer doesn't offer any leave as a benefit. The employee isn't eligible for leave under the employee's policy, or the employee has exhausted the employer's leave policy. So even if your work doesn't offer sick time or vacation, it can still be reasonable to request leave as an accommodation. And even if you've gone through all of your FMLA, you can still request leave as a reasonable accommodation. And so long as that's not an undue burden for your employer, then they should grant that request. So as I mentioned, an employer isn't required to provide paid leave. However, if it has a paid leave policy, then you should receive those benefits. So it would be problematic if your employer said, well, we have a paid leave policy, but because you're requesting a reasonable accommodation, it has to be unpaid. the employer should provide you with paid leave for the period of time it would offer as part of its paid leave policy. And then an employer also may not penalize an employee for using leave, and that can show up in a few different ways. So, for example, if an employer has a quota, like a work quota for a period of time, and the employee is out on leave, it would be unlawful for the employer to say, well, you didn't meet your quota because you were on leave. So your numbers for this time reflect, that you've had, you know, so for example, if the requirement was that, you make 100 phone calls a day as part of your job, but you were on leave, so it shows that you have 0 calls, your employer should not be penalizing you for being on leave and saying, well, you didn't meet your quota, therefore you're terminated. Other employers have, different leave policies that penalize people. So for example, some employers have leave policies where if you take, beyond 5 days of sick leave, you will be written up. Again, if you're using leave as a reasonable accommodation, your employer shouldn't be penalizing you for that. And that you should not be subject to, receiving write-ups for taking leave under that policy. So when you request leave, there's some things that you should be prepared for. Be prepared to provide medical documentation from your provider. And there's a few reasons for this. One, it can really help your employer evaluate the need for the leave, the amount and type, and whether alternative accommodations can be effective. It's also usually pretty important, just in terms of some of the case law, that medical providers are, supporting your request for leave, and we can get into that in the next slide. But typically there are a few things that your medical provider should be outlining to your employer when requesting leave. And then again, we just discussed that leave can be in different forms. So coming back to information from your medical provider. So one thing that to just keep in mind when requesting leave is that requesting leave for an indefinite amount of time isn't something that is a reasonable accommodation under current case law for Americans with Disabilities Act. Saying to your employer, hey, I need to go out on leave, but I'm not sure when I'll come back or when I'll be well enough again to work, is not a reasonable accommodation. And that would be something that your employer could deny and would be probably on safe legal footing to do so. And it also, I think that also plays into the undue hardship, in that, an employer probably, they need to be able to evaluate if they have somebody to do your position, how long can they hold it open for, those type of factors. And then when you request leave as an accommodation, you really should be specifying an expected return date. That doesn't have to be with certainty. It can certainly be an estimate, but you want to be able to show an estimate of when you'll return and when the disabling condition will resolve. And when I say the disabling condition will resolve, you don't need to show when your disability will end, but whatever the condition is that's requiring leave, it's important for your doctor to be able to say, in my experience, I estimate this current flare up of symptoms will resolve in 3 months. I think that's something that under current case law is something that's important to provide to your employer, and will also give your employer the necessary information they need to evaluate your request. And then if you are granted leave, make sure that you communicate with your employer, especially if there's changes in your status. So for example, if you are out on leave and you are, you feel like, my condition is improving, but I may need some more time. Um, I think requesting that from your employer and um, you know, circling back to them to let them know what your status is so that as your return to work date approaches, you know, you can be clear that, hey, I need another 5 days. Would that be reasonable? You know, that's something that's important to communicate with your employer because your employer will want to know when your expected return date is, you know, if you've been released to work. And they'll also, you know, want to know if you know, those are things that they'll need to evaluate to determine if any you know, extensions in your leave are reasonable. And then the other thing to note when requesting leave is that employers under the ADA should be modifying their maximum leave and no fault attendance policies if it's not an undue hardship. So maximum leave policies are those policies that say, you know, you can have no more than 5 days of sick time in you know, in a year. Otherwise, you know, you'll be penalized or you just don't get the leave. You still just need to show up. That may be a policy that they have chosen for all of their employees, but the ADA still applies to those type of policies. So an employer should be modifying those. And if due to your disability, you go beyond a maximum leave, you know, your employer shouldn't be writing you up for that. And they should still, it would not be appropriate for them to say, no, your request exceeds our maximum leave policy, therefore you don't get any additional leave. The employer should still you know, be evaluating if that is a reasonable accommodation request or an undue burden. And they shouldn't be, you know, just uniformly applying a maximum leave policy. So there's also, so in addition to leave, there's also the very important question about returning to work. And I think returning to work this can be a difficult time for employees. And it can be, you know, a particularly stressful time. But I think, you know, making sure that you're in good communication with your employer and with your doctor about your ability to be released to work is important. And you know, kind of knowing a few things up front can help make that process a little easier. So one thing that employees can find is that the an employer may say, hey, you can come back to work, but only if you can return to your job with no medical restrictions. So that's referred to as a 100% healed policy, in which the employer wants you to return with no medical restrictions. And that's a problem because essentially that's saying you can only return if you don't need any accommodations. And under the ADA, you know, an employee can request reasonable accommodations. So, so for example, if your job required a lot of lifting and your doctor released you to return to work, but you had a 20-pound lifting restriction, it wouldn't be appropriate for your employer to say, hey, you can't come back to your job until you can, you know, lift, you know, beyond 20 pounds. The employer should instead, you know, in that situation, what you can do as the employee is say, you know, I would like to consider a reasonable accommodation that would allow me to perform my current job. Or if lifting is really an essential part of your job, you know, if you have to lift above 20 pounds, you know, frequently throughout your day, and there's not really an accommodation that would allow you to do that, then you could also request instead reassignment. So, you know, even though you've been on leave and you may not be back to the condition you were before the leave, that doesn't mean you can't come back to work. You know, I would make it clear to the employer as you're coming back to work what accommodations you do need. And if those accommodations include reassignment, you know, then also make that clear to your employer, you know, and that process looks at what jobs are open and if there are jobs that you're qualified for that you could move into instead. So one of the things in terms of requesting an accommodation that I just wanted to cover is that it's a process when you request an accommodation that needs to be initiated by the employee. And you need to at least disclose that you have a disability. It's not really your employer's job to determine if you have a disability and offer an accommodation. That actually can lead to its own forms of discrimination. So that's why under the ADA, it's something that needs to be initiated by the employee. You need to be prepared to provide documentation of the need for the accommodation if requested. That doesn't mean your employer should be able to ask for all of your medical records, but it is certainly reasonable for them to ask for documentation that, so for example, what makes it hard for you to do your job? What is a requested accommodation, and how does that accommodation help you to perform your job? You need to be involved in the process of identifying effective accommodations. And this is really important because under the ADA, your employer has an obligation to talk to you about your accommodation requests, and you have the same obligation to talk with them. So if they're offering alternatives, rather than say, hey, that's not what I want, it's really, the responsibility of both parties to come to the table and say, okay, let's talk about these alternatives. Let's talk about the request. Let's see, what can be done that will provide an effective accommodation. Because if you don't engage in that process, then under the law, you're seen as pulling out of the reasonable accommodation process. And that's something that in terms of an ongoing claim can make it really difficult to prevail. And then also, I think it's important to document correspondence between you and your employer. Hopefully all of these things go well. We unfortunately only get cases where things have not gone well, but hopefully things go well. But I think it's still always good advice to document your correspondence and to provide written requests and those things. So what are some other tips and tricks when it comes to requesting accommodations? Have an accommodation in mind that will work. So one of the resources that you can use to think through and get advice on an accommodation request to ask is askjan.org. And they do actually have a phone number you can call to talk with someone, or you can also search their website to look at disabilities or limitations. And then they provide examples of accommodations. And it's a really helpful resource if you're trying to figure out what should I be requesting, what options are available. Again, when it comes to trying to think through accommodations and what may be helpful, I think talking to job coaches, friends, family, definitely your medical providers. Don't necessarily expect your employer to know that you have a disability. As we talked about, it's really, up to you to be able to ask, make that request and tell your employer what you need. And you can always, depending on the issue, you may need an ongoing or temporary accommodation. And it's certainly, very appropriate to ask for a temporary accommodation if that's what you need. And then I think it is helpful to work with your doctor to make sure their letter is helpful. I think there are times where unfortunately the letters from physicians aren't quite as clear. So I think talking to your doctor about, identifying what the accommodation, is being requested, how it supports you to do your job, how your medical condition has made part of your job difficult. I think those are key things to include, and that they're very, clear on the accommodations piece. The medical documentation can be really important for having a good interaction and getting a reasonable accommodation request. So what can you do if your request is denied? So you can definitely do some more formal and informal things. I think, talking to your employer about why it was denied is helpful. let your work know, just discuss if you, disagree with their decision. As we talked about, you can always ask for reassignment or ask for a different accommodation. If they say the initial one you asked for was unreasonable, you can get someone to help you, such as a union representative, a job coach, a lawyer, or family member. And then you can report to your human resources or file an official grievance with management. And then you can take more formal legal steps, such as filing a charge of discrimination with the Utah Anti-Discrimination and Labor Division or the Equal Employment Opportunity Commission. These are administrative agencies. UALD is a state agency that investigates charges of discrimination, and the EEOC is a federal agency. And what happens when you file with them is that you essentially write out in a document why you think you've been discriminated against, and then you file it with one of these two agencies, and then they assign an investigator who acts as a neutral third party who looks into the charge, collects evidence, and then makes a determination as to whether or not they think there has been discrimination. There are filing timelines involved with both of these agencies. So if you have currently faced a denial and you think you may want to file, I would definitely urge you to go both of their websites and look through the material and make sure you're within those timelines, and that you get your information, you get your charge in a prompt way. And I think that's everything. So it's about, there's about 13 minutes left. And so I'm more than happy to take any questions from the audience. Oh, and let's see, you can type those into the chat box. And Carly, is typing into the chat box the best way to ask a question?
Yeah, that would probably be.
Okay. A copy of the presentation available. Yeah, we'll make a copy of the presentation available. And then this is also being recorded, so we will post it to our website so that you can watch it again. And we've been trying to do these monthly. So this will also be posted to our website to view. And then we have a much more in-depth presentation from our last presentation that focuses on like all of the ins and outs about reasonable accommodation requests broadly. Today was more focused on work from home and leave, but we will be posting more of our presentations for folks. So did you say that FMLA could be used as a reasonable accommodation or just ask for leave? So that's a really good question on FMLA and reasonable accommodations. So I think one area where I usually see there getting to be confusion is that employers, I think usually what they usually consider first is FMLA. And then sometimes employers don't always consider leave as a reasonable accommodation. So just to be clear, if you, what FMLA leave is, it's job protected leave. So you under FMLA have 12 weeks of job protected leave where your employer cannot fire you for taking leave. So you could request leave as an accommodation up front. If you haven't used your FMLA, then you should also apply for FMLA, and you'll have 12 weeks of protected leave. If you have run out of FMLA, you can then request leave beyond the FMLA as a reasonable accommodation. So those things can kind of be used in tandem. And then if your FMLA leave runs out, you could ask for leave beyond 12 weeks. Has COVID caused more problems with leave and maintaining employment. I think that's one of our audiences provided a really helpful resource on, you know, on on accommodations during the pandemic. We also have a COVID related fact sheet on our website, but I think I haven't seen as many issues with leave as COVID causing problems with leave and maintaining employment. I've seen much more issues with working from home. So I have had, some cases where, an employee was told they had to come and work in the office, when individuals in their same exact position with the same responsibilities were able to keep working from home. These are always case specific, fact specific, but, based on, I have had some of those cases where I thought it was discrimination because their non-disabled coworkers were able to keep working from home. I've had employees who are immunocompromised due to their health condition, really struggle when there are requests to return to work. And that's where you have to really get into what are the essential functions of your job. Are there ways to make your job safe at work? If there's not, is there another assignment or another position you could request as a reasonable accommodation instead? Okay, so if someone has exhausted their FMLA and is not ready to go back to work, is it appropriate to ask the employer to lay off or terminate because they think it may be an indeterminate time they need, work from home is not available option? Um, so if you've exhausted your FMLA, but you need more leave, you can always request leave as a reasonable accommodation. Whether or not it's reasonable is always fact specific to your job. If you run out of FMLA and you request leave as an accommodation, and then you're terminated, that's certainly something that you would want to consult an attorney about. I think whether or not leave beyond FMLA is a reasonable accommodation. Like I said, is very fact specific to your position, how many other people can do it, what the office coverage is like, those type of things. But I think anytime, if you've exhausted leave and you're asking for leave as a reasonable accommodation and then you're immediately terminated, it's possible you may have, a claim of a failure to accommodate. If it may be worth mentioning that EOC has recognized that just because an employer has allowed an employee to work from home during COVID doesn't mean they must continue to do for. That's absolutely right. And I think, that certainly there are going to be times when, an employer may ask you to come back into the office. And if because of your medical condition, you need to keep working from home, that's where it goes back to some of those kind of specific factors that I was talking about. Is it, could you, are there parts of your job that you could do? Could you work in a hybrid environment in which you come in just 1 or 2 days a week? Is there a way to make your workplace safer if you're immunocompromised? Are other employees allowed to continue to work from home? Like I said, I've certainly had cases where I had an employee who was requested to come into the office, but all of their coworkers in the same position were allowed to continue to work from home. So, with all things with the law, it's really, kind of case specific. And if you ever have any questions, you're certainly welcome to call our office. If we can't provide direct assistance, then we'll certainly provide you with with referrals. So. Well, we have about 6 more minutes. I'm happy to take any other questions. If anybody has those. If not, I really appreciate everybody attending this evening. Like I said, we will have these posted on our website, and the next month presentation. These presentations are going to be on the 3rd Thursday of the month, and our February presentation right now is planned to be will be all in Spanish. So if please share that if you have individuals you work with or family or friend members who need a presentation about reasonable accommodation. That's all in Spanish. We will be doing that next month. And then I see there's a question here about a specific question about somebody's individual workplace. I would say I would recommend that you call our office and talk to our intake team to see these if this is something that we can provide any information on. Our phone number is 801-363-1347. But otherwise, I appreciate everyone's attendance for tonight.